Hi, my name's Ryan Heath, and I'm with Sarah Perna today, and we're going to talk about estate planning for the off-to-college student.
Ryan, we had a conversation recently with a client where you recommended that their college-age daughter execute some estate planning documents. Can you talk about estate planning for college students?
Sure. So many parents don't realize this, but once an adult child reaches 18, parents no longer have access to financial information about the child or medical information about the child. And so there are some basic estate planning documents that every adult child should have if their parents want to have access to this information.
And what documents would you suggest that they have?
Sure. So for adult children, there are 3 or 4 primary documents and then some optional documents as well. So at a minimum, each adult child should have a financial power of attorney, a medical power of attorney, a HIPAA authorization, and a declaration of guardian. So every adult child needs to have a financial power of attorney in place. And a financial power of attorney would allow parents to access the child's bank accounts in the event of an illness or accident. And so many adult children, especially those off at college, receive scholarships and financial aid payments. Many of them work. And so their accounts can accumulate a significant amount of assets during the school year. So by having this financial power of attorney in place, parents would be able to access the account, pay tuition, pay for rent, and also pay medical bills for that child. So that's on the financial side. On the medical side, there's also a series of important documents. So the medical power of attorney is extremely important for parents to have. So the adult child would be able to choose which parent would step in and make medical decisions for them in the event they were unable to communicate with their doctors. So again, really important if a child's away at college and has an accident or illness, that a parent can step in and make those decisions for them. The HIPAA authorization is also tremendously important. So a HIPAA authorization would allow the child to name their parents as authorized persons to access information about medical history, treatments, and diagnoses. And so I had a scenario not too long ago where a parent called me frantically in the middle of the night. Their child was in a car accident. They were calling the hospitals to find out which hospital the child was being treated in. And the parents were not allowed to get any information about their child. So if the HIPAA authorization was in place, the parents could have accessed that information. And lastly, a declaration of guardian is important, really from the perspective of if there's some sort of long-term injury or illness where a guardian needs to be appointed for that child, the child can choose which of their parents they'd want to serve in those roles, and they can also prohibit someone from serving in those roles.
Okay, so we have the financial and medical powers of attorney, the declaration of guardian, and the HIPAA authorization. Are there any other documents that you would request?
So depending on the child, their age, their financial assets, a will and or a directive to physicians may also be important. For the will, really it comes down to the amount of assets the adult child has, and whether or not they'd like to leave those assets to specific people. And on the directive to physicians, that's our end-of-life pull-the-plug document. And so some children, even at 18 or 19 years of age, have really strong religious or personal beliefs about end-of-life treatment and care. And so for those individuals, a directive to physicians is a very important document for them.
Okay, so once we have all of these documents signed, what's the next steps? What do we do with them?
Sure. So signing the documents is great, and that's our first step. But then we have to give the documents to the appropriate people so that the plan is implemented. And so on the medical side of things, our medical power of attorney, our HIPAA authorization, directive to physicians if a child chooses to sign one, we want to give those documents to any of the child's physicians, healthcare providers, the school, medical facilities, anywhere that the child may be admitted for treatment. On the financial side of things, we want to make sure that the child's bank accounts are accessible. And so we want to bring that financial power of attorney to the child's bank, get it approved and filed along with their account paperwork so that if there's an emergency, we have access to those financial assets.
Absolutely. So do you have any final thoughts on estate planning for college students?
Yeah, so we never want anything bad to happen to our children, right? But ultimately, bad things do happen, and we want to be prepared. And so these basic estate planning documents can give both parents and children a great peace of mind, especially before heading off to college.
For sure. Thanks, Ryan.
And that wraps up our conversation on estate planning for college-age students.